Okay, the numbers seem to be slowing down a bit, and I've just got some introductory remarks as people continue to come in before the main program goes. So welcome everybody to Gowling WLG in our Spring Construction Law Forum. My name is Ted Betts. I'm the head of our Infrastructure and Construction Group at Gowling nationally and internationally. Very delighted to see everybody, at least virtually. I see a lot of familiar names. Would be great if we could be collecting together and shaking hands and tipping coffee, sharing coffee together or something. That's not to be this year, but I do hope everybody's healthy and safe. It's obviously been a very challenging year for everybody, in particular in our sector. I think we're on our third or fourth or fifth lockdown now. I've kind of lost count. It's been going on for so long, it seems, across the whole country, with really unimaginable impacts and delays on our various projects. Not to mention the concern we all have for our personnel and our staff, as well as our families and friends. Well, we're here to help with the unimaginable, to talk about a lot of that today, because the unimaginable needs to quickly become very imaginable when we are trying to complete a project, and we have to deal with it in real life. So we're going to be tackling some of those issues today. For those who are new to our construction law forums, we hold these twice a year, once in the spring and once in the fall. We've been holding them in person in Toronto for about 6 or 7 years now. And it's a great time to gather and collect with like-minded, industry-focused content and updates as the law evolves in our sector. Since we're online, we have expanded nationally. So this is a great crowd. Looks like we're approaching 200 people. We had 300, what was the last count? 355 people registered for this program, which is really exciting and great for us to hear, to see that we're reaching and connecting with so many people across the country in our sector. We've got a packed program though, so I want to get underway. Just a couple of housekeeping notes. We have everybody muted during the program. Feel free to ask questions using the chat features. We are in a typical Zoom format though, instead of a webinar format, because later on we will be unmuting everybody as we join into the breakout rooms, which is something new that we're adding, and I'll talk about in a minute as well. The program is being recorded, and so in a few days you'll be able to access it on our website. If there are others in your organization you think you should see it or benefit from that, of course you can always reach out to any one of us to follow up with follow-up questions, or in our breakout session, which are going to be province specific, feel free to ask your questions then as well. We have an exciting program. There's a lot of new that has evolved over the last while. Obviously, COVID is on all of our minds. We've got a great presentation today from two of our employment lawyers. Everybody has been quite focused on whether projects can continue or be shut down, or what are the delay claims. We're going to spend some time today talking about the actual impact on employees in the workplace with two of our amazing experts on that. Cindy Koo is going to tell us a little bit about the new CCDC2 that came out in December and some of the updates to that standard form contract. But we're going to start, as we typically do with these construction law forums, with a case law update so that everybody's aware of what's evolving in law in our sector. So Sahil Shur, one of our partners in the Kitchener-Waterloo office, is going to take over right now and tell us about what's new in law. Over to you, Sahil.
Oh, thank you, Ted. Good afternoon, everyone. My name is Sahil Shor. I'm based out of the Waterloo Region office, and I'm going to speak to you today about the cases. I've picked 6 from the last year, which I've written on all 6 of them. So I invite you to, look at these building brief articles on these cases on our website. But today I'm going to focus on this 6. So I'm going to start with an occupational health and safety case having an impact on a construction project in the city of Sudbury. Next slide, please. So this is the most recent case from Ontario Court of Appeal released in late April. We issued a building brief on this, Tushar and I, couple days ago. In this case, what happened is in a construction project, an individual is struck and killed by a road grader driven by an employee of a paving company, which is hired by a city of Sudbury. And both the company and the city is charged with violations of the Occupational Health and Safety Act regulation. The city is charged as both a constructor and an employer. The matter goes to a hearing, and it is determined, and which was upheld at the divisional court, that the city was neither an employer nor a contractor for the purposes of the Occupational Health and Safety regulation. Next slide. The Crown appealed the decision to the Ontario Court of Appeal, and one of the questions that was posed to Ontario Court of Appeal was whether or not the city was an employer under the Occupational Health and Safety Act regulations. And to answer this question, it was necessary to determine whether control was a requirement where city hired a third party, which happens in the construction projects, where an owner and a contractor in the contract requirements deal with health and safety concerns. And then, if it was found that the city was an employer, did the city have a successful due diligence defense? Court of Appeal went in a very thorough analysis pertaining to several definitions, including most importantly of an employer and a constructor, and held that the city was in fact an employer within the meaning of the Occupational Health and Safety Act, because the city employs its own safety inspectors to go on site on numerous occasions, and therefore it was liable unless the city was successful to establish a due diligence defense. Next slide, please. And the analysis continued by the Court of Appeal to basically say that the employers are in a position of an insurer who must take certain health and safety regulation compliance before work is undertaken. And with respect to the city's due diligence defense, the city argued that it met its obligation through its tendering process. However, facts concerning the due diligence were not sufficiently addressed, and the matter pertaining to the due diligence defense is sent back for another hearing. So depending on how that hearing proceeds and what comes out of it, it is a case that has very, very broad implications to construction projects. Next slide, please. And the significance really is because it applies to infrastructure construction projects and owner liability as an employer under Occupational Health and Safety Act. And city as an owner assumed heightened liability by virtue of sending its inspector despite not directly overseeing the grading work. And there's then overlapping duties of workplace parties that can exist in construction site under Occupational Health and Safety Act. Next slide, please. So the next case that I'm going to speak to you about is the case of Trembler. This is again a 2020 decision from Ontario Superior Court of Justice pertaining to what happens on a construction project very frequently, where a subcontractor enters into a contract to supply material and services, and there is no direct contract between an owner and the subcontractor, and when a subcontractor is not paid by the party that it has a contract with. And that's exactly what happened in this case. Trembler entered into a subcontract with a numbered company who had a contract with the owner, did not get paid, and Trembler then sued the owner for approximately $31,000. Next slide, please. And the contractor files for bankruptcy, and Trembler, of course, is entitled to register a claim for a lien under the Construction Lien Act, but it did not register a claim for a lien. Instead, it started a breach of trust allegation and claim against the owner, number one, and also a claim of unjust enrichment against the owner. Next slide, please. The court held that Trembler did not have rights to either breach of trust protections by the Construction Act or the unjust enrichment doctrine, because there was no contract between Trembler and Lighting Boutique as the owner, it meant there was no trust funds which were held in trust for Trembler, and the Section 8 of the Construction Act obliges contractors and not owners to retain trust funds for the benefits of the subcontractors. Next slide, please. And the analysis also continued to suggest that allowing Trembler to use the trust claim would create a new remedy not contemplated by the Construction Act and would effectively require owners to ensure that the contractors distribute their funds properly, and the divisional court was not willing to take this step. Next slide, please. And with respect to Trembler's claim for unjust enrichment, the court held that the contract was between the owner and a contractor, which provides a jurist reason to prevent unjust enrichment claims by subcontractor against owners. And in this case, the divisional court went a step further and confirmed that the Construction Act does not provide for unjust enrichment claims where there is no privity of contracts, i.e. between the subcontractors and owners. Next slide, please. And what is the significance? It is a very relevant decision for subcontractors where contractors face bankruptcy, and again, also very important to owner to think about when there's no privity of contract with subcontractors and trust claims are made against them. The next case I'm going to speak to you about is the case involving the construction of a hospital and really the analysis that come into play when a project is delayed, and not by one party, but there's concurrent delays taking place on the project, and the court is asked to analyze that delay in order to make a finding. So in this case, a subcontractor, an elevator contractor, brought a $1 million claim against the contractor for unpaid services and materials. The contractor counterclaim for $2.2 million, mostly related to the damages, and it argued that other concurrent delays caused during the same period by subcontractors, and the subcontractor who commenced the $1 million claim was responsible for its share of the delay. And what it had to establish was that the subcontractor was responsible for delay causing the contractor to experience losses. Next slide, please. And the court had to go through analysis of concurrent delay, which, as the industry participants you will know, is complex and it's quite sometimes speculative, because it requires a very, very comprehensive breakdown of overall delay and apportioning of time and responsibility and cost. But in this case, the court provided very realistic view, and this is the case that has been welcomed by delay consultants, that it is not necessary for the independent causes of delay to occur exactly at the same time for them to be considered concurrent. Instead, it is rare that the concurrent delays start and end at the same time. Concurrent delays are more commonly experienced as overlapping events. So in this case, the subcontractor was delayed, resulting in some damages, but it did not cause the material delay to the entirety of the project. Next slide, please. So again, significance is the direction for assessing concurrent delay that will result in fair and just results. And the courts have recognized that on the complexity of a construction project, and that it is sometimes unrealistic to reach a precision determination as to who is responsible for the delay. The next case I'm going to speak to you about is again the Construction Act and the trust provisions. The case is from the Ontario Court of Appeal involving Urban Corp, Cumberland, a residential condo developer goes bankrupt, is granted insolvency protection under both BIA and CCAA. The Cumberland Group starts the proceeding under BIA. Proposal trustee is court authorized, approved investing order and sale process order to conduct sales is granted in order to sell the condos which were built. Next slide, please. And what happens is, and a further order is granted, allowing Cumberland Group protection under CCAA and appointed proposal trustee for the sales to continue under CCAA. But what happens is that the contractors and the subcontractors who built and supplied services, time, and material to the project in question were owed $3.8 million, and they claimed statutory Section 9(1) trust arose in favor of them from the sale proceeds of condo units. Next slide, please. And the Court of Appeal in this case reversed the motion's just rejection of Section 9 of the trust provisions from the Construction Act. And it basically said that Section 9 of the Construction Act provides for a trust in favor of unpaid contractors over the sale proceeds of a certain property. And because the monitor had brought motion and the judge had determined trust was not created because of the sale proceeds, it was not because as a result of them not being owner, that does not matter. Next slide, please. And the court agreed with the appellants that the units were sold by the owner irrespective of who it was, and the fact that the monitor or the Cumberland Group were entitled and entered into sale agreements did not deter the fact that they were the sellers of the units. Therefore, the units, it was irrelevant as to who effectively was the representative of the owner and who had the control over the sale process. Next slide, please. So it confirms that the Section 9 of the Construction Acts create a valid trust in accordance with the general trust law. It does not conflict with either BIA or CCAA. And the trust that is created under Section 9 can only be displaced by the doctrine of permanency if it conflicts with specific priority. And the court also distinguished this particular case from a number of other cases. Next slide, please. And again, this is of significance for insolvent owners, and it also provides reassurance to the contractors that may hold a valid trust to the sale proceeds, but contingent on the fact that the sale proceed exceed the debt and other priorities granted under the federal legislation. Next slide, please. So the last two cases I'm going to talk to you about are the duty of good faith and the most recent cases from the Supreme Court of Canada. This one released in late 2020. That basically is the duty of good faith cases. The facts. Both this case and the case on Basetex services were heard together, but the decisions were released at different times. In this case, a group of condo corporations, Baycrest, engaged a contractor for winter maintenance agreement for a 2-year term, and there was a provision that the Baycrest could terminate without cause for giving 10 days notice, and they had a separate agreement for summer maintenance. Next slide, please. And to avoid souring the relationship and giving the notice, Baycrest decided to delay informing the contractor of the termination decision until after the summer work was complete. And therefore, in April 2013, they terminated the agreement before the following winter due to multiple complaints. And throughout spring and summer, they had several discussions with the directors of Baycrest to renew the winter contract for additional 2 years. And in these discussions, Baycrest did not disclose its intention to terminate the existing winter contract. And that was the issue that went all the way to Supreme Court of Canada. Next slide, please. And the analysis from both the lower courts and all the way to Supreme Court found, the Supreme Court of Canada in particular found that Baycrest breached its duty of honest performance and knowingly misled the contractor into believing that Baycrest would not terminate the winter contract. Next slide, please. The significance is very, very important in negotiation of the construction contracts and also in implementation of the contracts, including renewals, that the court has clarified the duty of honest performance and the obligations pertaining to the performance of the contract and rights of renewals. The scope of duty is controlled and links to the performance of the terms of the contract. Dishonest performance is highly fact-specific, and parties may be found to mislead where they fail to correct misapprehension caused by own conduct, and that's what happened in this case. The next case and the last case I'm going to speak to you about is, again, from Supreme Court of Canada, WasteTech Services. The decision is released early this year. We wrote a building brief on this case. The facts involves, again, a termination of the contract and not a contract not getting renewed. Next slide, please. And the contract had an operating ratio as to how far the garbage would go in order for the contractor to collect money from the Greater Vancouver Sewerage and Drainage District. So WasteTech brought a claim alleging that Metro breached its duty of good faith when it allocated waste that prohibited it from meeting its target profit. And again, all the way to the Supreme Court of Canada. Next slide, please. And the Supreme Court of Canada held that if a contract allows for a choice, then the parties must exercise their discretion in terms of that choice, which has to be consistent with the purpose for which it was granted in the contract, or in the terminology of the organizing principle in Bassin, to exercise the discretion reasonably. Next slide, please. And then a party's decision must be connected to the reason it was given to the power to make that decision in the first place. And it goes on to explain and provide context, both what reasonable and unreasonable circumstances are, and it depend in large part in terms of the context and the intention of the parties as disclosed by the parties under their contract. Next slide, please. Again, another good faith series cases, and it provides guidance on discretionary powers, both objective measurement and subjective measurement, and also the discretionary powers not readily susceptible to objective measurement. Next slide, please. Again, something to think about, given these two directions from the Supreme Court of Canada on two of the cases in terms of how your contract is structured and how you're using the terminology and the manner in which the provisions are drafted in order to implement the work and reliance on the underlying contract. Next slide, please. So that's it for me. I am going to be monitoring the chat functions. If you have any questions pertaining to any of the cases that I've spoken to, please send them across. Over to you, Cindy. Thank you.
Okay, thanks, Sahil. Hi, everyone. Thanks for taking the time to join us today. My name is Cindy Koo. I'm a commercial associate in the Toronto office of Gowling WLG. I work primarily in the construction and tech sectors, and I draft a lot of construction contracts. So in our 10 minutes together, I will highlight 5 of the major changes in the new CCDC2. My colleagues Ted Betts, Magda Hannebach, and Karina Labelle have written an in-depth article about the changes, and that article is available on our website. Just before we jump in, I had an interesting question from a client recently about a CCDC2 that I'd like to poll the audience about. So Shannon, if you could please bring up the poll. I'd like to know if anyone has ever used or considered using a CCDC2 primarily to buy or sell a major piece of equipment for a construction project. I'll just give everybody a minute to respond. Shannon, do we have results? Oh, okay, interesting. Thank you, everybody, for responding. So for anybody who answered yes, or who is interested in a construction contract that relates to equipment supply, I would love for you to get in touch with me and tell me about your use case, especially if your equipment involves some technology transfer or licensing. So moving back to our scheduled topic, thanks, Shannon. I see we have a few audience members who are new to the CCDC. So 10-second primer. CCDC stands for the Canadian Construction Documents Committee. And this committee creates standard form construction contracts that are widely used in the sector. Each form has a number and a year. The number refers to the type of contract and the year refers to the last time it was updated. So the CCDC2 is a stipulated price contract between an owner and a contractor. It was last updated in 2020 and before that in 2008. The CCDC is hoping that everyone will use 2021 to transition from the CCDC2 2008 to the CCDC2 2020. The CCDC2 2008 seals will be available until the end of the year, and anybody wanting to exchange their old ones for the new ones will be able to do that. And we expect the other CCDC documents to be updated in due course. Next slide, please. Okay, so highlight number one is that the CCDC2 now has captured the prompt payment and adjudication legislative changes brought in by the Ontario Construction Act in the last few years. As many of you already know, various other jurisdictions across Canada are considering adopting prompt payment and or adjudication mechanisms as well. So the CCDC2 now has this concept of payment legislation, which means any legislation that relates to payment under construction contracts at the place of the work. And so now the new CCDC2 has updated requirements for invoice contents, procedures for processing invoices, and payment timelines. And its contractual framework, of course, prioritizes compliance with payment legislation where it exists. So this will help the CCDC2 stay relatively timeless as other jurisdictions bring payment legislation online. In the interest of time, I won't run through all of the details on this slide, but I will flag 2 points regarding payments. Just as an example of that prioritization of compliance with the payment legislation, the new CCDC2 requires holdback to be paid within 10 working days of the expiry of the lien period, subject to payment legislation. In Ontario, the Construction Act requires release of holdback on the day following the expiry of the lien period. So notwithstanding the 10 working days part, owners in Ontario will still need to release holdback on the day following the expiry of the lien period. I'll also note that the new CCDC2 has picked up 2 very popular supplementary conditions in respect of invoice contents. So now with every invoice, the contractor must submit evidence of compliance with workers' compensation requirements, and for every invoice after the first, a stat deck. The CCDC2 now also acknowledges that the dispute resolution provisions in the contract do not interfere with any adjudication that is prescribed by law. Next slide, please. Highlight number 2. Let's talk about this new concept called ready for takeover. With this concept, the CCDC2 has created a more rigorous substantial performance of the work milestone. So the old definition for substantial performance of the work was referred to the definition under applicable law. And some jurisdictions didn't have a statutory definition for substantial performance. And so the CCDC definition of substantial performance of the work was simply when the work was ready for use for the purpose intended as certified by the consultant. So now what the new CCDC has done is it's created this ready for takeover concept that sits on top of any available statutory definition. So as we can see in the list on the right side of the screen, the requirements for a contractor to apply for ready for takeover include the work reaching the statutory definition of substantial performance if any exists, the work complying with the requirements for occupancy, as-built drawings completed as of the date of that application being provided, and if specified by the contract requirements, various other requirements. So naturally, where the CCDC2 had substantial performance of the work as a milestone or trigger for various obligations under the contract, this has now been updated to reference ready for takeover as a milestone instead. Next slide, please. Okay, highlight number 3. For highlight number 3, we'll talk about this brand new concept of early occupancy. So early means before the work has reached ready for takeover. The owner can occupy early if the contractor agrees, acting reasonably, and the relevant authorities approve. The owner can occupy all of the work or part of the work, and as you can see on this slide, there are different obligations that occur depending on whether the owner occupies part of the work or all of the work. In the interest of time, we'll move to the next slide, please. Highlight number 4 on construction safety. The CCDC2 makes it clearer that the contractor is responsible for the health and safety program at the site. So you'll see the underlined words in the first bullet are the additions that the new CCDC2 has added to clarify the scope of the contractor's health and safety obligations. the owner now also has to require all of its own forces, the consultant, and any of the owner's contractors to comply with the health and safety program at the site. Both parties are expressly obligated to comply with health and safety legislation and the health and safety program at the site. It may still be a good idea to keep the previously very popular supplementary condition clarifying which party will be the constructor or prime contractor, depending on your jurisdiction, for health and safety purposes. I know that I will definitely be watching the Sudbury decision relating to this point, as Sahil talked about earlier. Next slide, please. Last highlight on indemnification. The scope of the indemnification provision under the new CCDC2 has changed in 4 notable ways. First, there's a narrowing of the scope of the mutual indemnity for negligence. It used to be that each party indemnifies the other for its own negligent acts or omissions, and for anyone whose acts or omissions the indemnifying party is liable for. Now, each party will still indemnify the other for its own negligence, but only the negligent acts or omissions of those for whom the indemnifying party is liable. So this reads like a catch-up change, but I think it's important for each party to think through the implication of this change in their own context. The contractor is still under, or is under GC 3.6, liable to the owner for the acts or omissions of its subs and suppliers, and it may be a good idea to clarify what the scope of this indemnity means in the context of that obligation. Second, the mutual indemnity for parties' losses is now limited to direct damages only. Third, the indemnity for all third-party claims is now uncapped. This is a significant change. Previously, only third-party claims for death, bodily injury, and property damage were uncapped. Third-party claims now joins liability for toxic and hazardous substances, patent infringement, and issues with title to the place of the work as uncapped liabilities under the CCDC2. Lastly, the indemnity cap for a party's own losses for which insurance is required to be provided has doubled, going up from $5 million to $10 million. This is because the CCDC 41, which is the insurance document, was also updated at the end of 2020. So for any projects that had bid closing after December 14th, 2020, these changes, among others, would be in effect. So what are the takeaways? Number one, try to review and update your CCDC2 supplementary conditions this year. And number two, have your insurance advisors or risk management team take a look at the CCDC 41 2020 sooner rather than later. Ask these folks to make sure that the insurance requirements in the new CCDC 41 meet your project's needs and that your existing coverage meets the new contract requirements. We've helped a lot of clients update their CCDC2s already and would be happy to answer any questions. Just before I hand it off to Nina and Tushar, a little reminder for anyone interested in talking about equipment supply and construction contracts, especially those that involve technology transfer or licensing. I'd love to be in touch and learn more about your use case. So thanks everyone and have a great afternoon. Over to you, Nina and Tushar.
Good afternoon, everyone. Thank you so much for taking time out of your busy lives and busy afternoons, depending on where you are. It could be morning on the West Coast. But thank you so much for joining us. Nina and I would like to walk you through everyone's favorite topic. You guessed it. It's employment law in COVID-19 times. So maybe Nina, I can start us off with respect to COVID-19 workplace safety plans. And really, I think a good way to think about this particular requirement under law, and I'd like to frame it in terms of a requirement, is that this is mandatory. We are in month 15 of the pandemic, leading into month 15 of the pandemic, and at this point in time, we've been seeing reports from various regulators around the country saying we have hired 150 new enforcement officials to walk around your job site and enforce the mandatory requirements under law. And so, really, this slide should be called mandatory. Key considerations for your COVID-19 workplace safety plan. We've borrowed these from the Ontario Ministry of Labor's guidance documents, as well as the guidance documents from the PSHSA, the IHSA, and a couple of other industry regulators as well. And I see Nina has just put up a very valuable link in the chat where you can actually get a template, a preferred template COVID-19 safety plan in order to build yours out. I'd like to talk about the key considerations, really common sense stuff. How are you ensuring that your workers know how to keep themselves safe? What are you doing to screen, active screening day by day? How will you control risk of transmission? What are you doing to make sure that if there is a potential case, you are taking all appropriate legally required steps to cover off against those risks? How will you manage risks caused by workplace changes, restructuring of workflows, staggering of shift start times, issues that are coming up day by day, moving around of break rooms and closing off of publicly accessible areas? How will you make sure your plan is working? I'd like to reinforce that last piece. What's the point of going to the trouble of developing a COVID-19 workplace safety plan if, when a public health regulator attends on site, you have to pull it out and blow a plume of dust off of it? Not effective. So we want to be mindful of enforcing the, not so much enforcing, but adhering to the plan and making sure that all of our employees are doing the same. Train, update, revisit your plan regularly, because these days the regulations are changing faster and with shorter notice than ever before. And this is, I would say, one of the longest standing requirements under occupational health and safety law, which applies to a construction employer just as much as it does to any other employer. Nina, this is a common sense point. Maybe we can talk a little bit about one of the question marks that employers are dealing with in these particular times.
Well, thank you, Tushar. I have to tell you, the number one question I get is, what happens if there is a positive COVID-19 test in the workplace? How do I respond? And I feel like screaming at them, well, that's dealt with in your workplace safety plan that we worked on about 10 months ago, which obviously you haven't looked at, and you've been lucky enough that you haven't had a positive case in 10 months, so you've forgotten about it. So that's number one. Number two is your public health authority. So Public Health Ontario has offices and subdivisions in each jurisdiction, should be your next best friend. And when in doubt, be conservative. I don't know if you've got a slide on some of, well, I think we're going to get to some of the nifty things that you can do in your workplace later, but I really encourage you to consider COVID-19 from that classical health and safety obligation that you have as a constructor, general contractor, or subcontractor. Next slide, please. So I'm going to take this one, which is vaccination in the workplace, which is the one I do get all the time, Tushar, and you and I have a bit of reputation in this area. And the number one question I get asked is, can you legally require an employee to get vaccinated? And I would say a qualified yes. And why it's qualified is if you're unionized, and I looked at the list before we just joined, and there are some unionized workplaces, there's a whole issue of negotiating with your union on mandatory vaccination. Secondly, even if you're not unionized, you will absolutely have to deal with issues regarding human rights, disability, religious exemptions. And finally, and I think this is the right thing to ask, is this the right way to do it in your workplace? Because do you really want the pushback? The pushback is actually less than we thought. I listened to a great article, Tushar, or a great podcast this morning about how vaccine hesitancy in Canada is actually being actively reduced. So as people see thousands of people being vaccinated, and as people see the low rate of risk, people are more open and accepting of vaccinations. If you're going to have some vaccination in the workplace, if you're going to sort of go and encourage it, we both believe the best way to do it is by incentivizing people. We found that really works. The number one incentive, give people paid time off to get vaccinated. So as soon as they get that appointment, tell them to go and take it, so that they're not trying to wait for an appointment 2 weeks now from on a Saturday evening. And if you're going to pay for it, and we know that several jurisdictions have mandated vaccination pay, you can ask for proof of vaccination for the purposes of reimbursing them for the time that they missed. Now, we hear lots of talks about vaccination passports. In the interest of time, I'm not going to deal with that. Let's just say we're waiting for Premier Ford and Justin Trudeau to figure out what they want to do on authenticating whether a person has been vaccinated or not. So where do we go from here, Tushar? We've talked a little bit about the pinch points, and you and I have really discussed what constitutes a real human rights exemption to the obligation to be vaccinated. Interestingly, the cases we have so far deal with masking. Now, I don't know about you, but now it's like keys, the car, my purse or wallet, and my mask. I don't leave the house without it, but people object to it. There's been some really good cases which say just because you say you have a disability doesn't mean from a human rights perspective, you don't have to prove that you can't use the mask due to a disability. So that's number one. Most people who are working in construction are not going to be so deprived of lung power that they can't wear a mask. Why is that important? That tells me a philosophy of the tribunals, Tushar, that they're going to look behind an allegation, oh, I can't do this because I'm disabled, with some degree of rigor. And they're not going to allow a legal argument to become a vaccine hesitant or anti-vaxxer's excuse not to get vaccinated. There are some risks. We talked about it. Certainly if somebody's required to get vaccinated, we've seen that in the healthcare sector. If they have a side effect, that would be covered by workers' comp. If there's a massive reaction, there may be liability. I don't think the employer would be held liable, but the employer would be named, I'm sure. And of course, that's why we say incentivize people rather than force people. So, and then I guess we get into workplace testing, Tushar, and I know you and I have done a lot of work on this rapid antigen testing program that I think is a very useful tool. I'm wondering if you can tell us what you've learned about that.
Most definitely. Thanks so much, Nina. I think the really interesting thing about framing things in terms of vaccination and then moving straight over to workplace rapid antigen testing is that mandating vaccination or considering that issue and incentivizing vaccination now, it focuses a little bit on where we are going forward. We're still in a supply limited state. We are assuming that vaccines will be freely available to mandate, which we don't quite have just yet. But workplace rapid antigen testing is, I truly believe, where employers should be focusing their attention as we speak right now. So an interesting case that came out of our backyard over here in Kitchener-Waterloo region is the CLAC versus the Crescent Care Nursing and Retirement Homes decision. I'd like to chat about this decision, but maybe for those that don't quite know what rapid antigen testing is or what it entails, a little bit about that and distinction points between the rapid test and the quote unquote brain tickler that we see on the news and that isn't super comfortable for those that have already gone through it.
It is removing your brain through your sinus test. Like, it is an awful PCR test. I don't like it, but tell us why rapid antigen testing is better.
Absolutely. Yeah, no, I'm happy to. So we have this concept under the rapid testing framework of supervised, the 3 S's, supervised self-swabbing, self being the key implication there. There isn't somebody leaning into your car with an angled Q-tip, tickling and removing parts of your brain from your sinuses. Effectively, it is as easy as brushing your teeth in the morning. That's one way our premier actually framed it. And so what is the rapid antigen test versus the PCR test? The PCR test is administered, at least to date, by public health. You go into your public health unit, local branch, your hospital, your testing center, drive-through facility, whereas your supervised self-swabbing can actually occur pretty much anywhere. There really aren't very many limitations to it. And the turnaround time for a quote unquote preliminary positive or a preliminary negative is 15 minutes, just about 15 minutes, which is much faster than the 24 plus, possibly 3-4 days, depending on how busy public health gets, to deal with the PCR test. And so we're talking about speed here. The reason I raised the Crescent Care case is because they actually looked at a policy in a unionized environment where an employer mandated that employees coming in had to submit to a PCR test every couple of days, every set period of time. And the union filed a grievance. They said, this is invasive. We have a griever. She suffers from successive nosebleeds. We have real significant issues with respect to privacy. I'd like to talk about one particular quote that the arbitrator raised, which is just, I love it. In my view, when one weighs the intrusiveness of the test, the brain tickler, a swab up your nose, a swab up your nose every 14 days against a problem to be addressed, which is possibly significant risk to life in a long-term care facility. And I don't know if you've turned the news on recently, Nina, but long-term care facility. Preventing the spread of COVID-19 in the home, the policy is a reasonable one. And so this was the more invasive PCR test versus we're talking now about the significantly less invasive brush your teeth, rapid antigen test. And so where do we go from here? We think of this as a reasonable, low risk proposition for an employer that they can mandate in real time today, as long as they can get their hands on rapid antigen tests and as long as they're meeting the relevant requirements within their jurisdiction. So I'll talk briefly about this. I know we're running up against the timer here. So the first stream, at least for Ontario employers, we have this provincial antigen screening program, which is basically public health's baby. There is a mechanism for signing up. They will run the show. They will post up. They will set up a tent. They will come on in, train your staff, and effectively administer this at your workplace. Key focus being on workplace transmission. We saw these in the early days at some of the really large employers. Training, collection, disclosure, this is their baby. They effectively are offloading some of the risk, so to speak, but you have public health officials crawling all over your workplace. So, take that as it will. Next slide, please. Now we also have this second framework, which is effectively a form of deregulation, and it's called privately initiated testing. At least it is in Ontario. It might have a different name in your respective jurisdiction. We've seen some similar offshoots in Nova Scotia, a couple of other provinces. So what is privately initiated testing? Basically, it allows a third-party private sector enterprise construction employer to deploy a rapid testing program in a controlled setting at their workplace. Why is this important? It operates outside of, at least notionally, outside of the public health system, although there are some tiebacks which are required to meet. So we're talking about, occasional reporting of preliminary positive tests and certain other compliance requirements that might be in place for quality control for these fancy rapid antigen tests. And so those are really a couple of the mandatory requirements. But key feature here is that because public health isn't supervising, actively participating, the employer has to account for the legal risks, operational risk, human resources risk, and costs and efficiencies associated with that, as well as some legal risks that are sort of bulleted in the lower part of the slide here. Privacy. We're talking about personal health information belonging to employees and essential visitors, and civil exposure possibly if in the unlikely circumstance there is some form of incident. And so we might be looking at insurance possibly, or some form of, if we go down the extremes, workers' compensation claim or something along those lines. Finally, what do you do if a person tests preliminary positive? Because remember, we're talking about the screening test here, not the diagnostic test. I think the implications need to be abundantly clear to anybody who's submitting to the test, and you need a signature from that individual beforehand, as well as their contact info for contact tracing purposes, that they understand the implication of a preliminary positive. What does this mean? It means if they test preliminary positive, the employer has to tell the public health unit, at least in Ontario, and they have to contact them, notify them, and the public health unit knows. And if that person doesn't then go book their regular PCR brain tickler test within a set period of time, they are presumed to have COVID-19. That part needs to be clear. And so, Nina, we've been working on a couple of different versions of this throughout the past couple of weeks, and with really good success.
Great success and great take-up. I mean, it's really interesting. Employees want the convenience of knowing that they're safe, and quite frankly, that they're not going to get COVID in the workplace and give it to their families and loved ones. So it's been almost liberating in some workplaces. And it's good to see. So there's because it's not the brain tickler, although I'm telling it's remove sinuses, seriously, it's not a pleasant test, but because it's so easy to do, it really doesn't have the backlash that we've seen with respect to PCR testing and obviously with vaccinations. And also, for those who are vaccine hesitant, they're worried about taking something into their body that is going to permanently alter their body. Obviously, taking a swab, again, doesn't have that same psychological resistance. So it's been a great initiative. I've put some links into the chat to Shar that people can look up. Many chambers of commerces across the country are helping facilitate it. I encourage you to look at whether this is a good solution for your workplace, especially if you're running multiple crews and the crews are not in pods and they're sort of working one with the other. Great solution. Next slide, please. So, Tushar, you and I have worked on closures, and this is not a happy thing. And obviously our slides are Ontario specific, but this is scary, quite frankly, that public health can close down your business. Can you talk about your experience, without naming names, of course, of some of the ones we've worked on?
I'll do my level best, Nina. So 2+ cases equals you need to report. That doesn't mean 2+ employees. 5+ cases associated with your workplace within a 14-day period means, at least in Toronto, Hamilton, and the region of Peel so far, and others are sort of indicating that they might be going in this direction as we move through this third wave, that your workplace can be closed down for a quote unquote minimum of 10 days. 10 calendar days. And so think about what happens in 10 calendar days. That's a long time for a project when you have such a short building season. And so a couple of things on the class orders and what you might be seeing in terms of facts and circumstances on the ground in your jurisdiction. These powers are not new. They are not exclusive to these 3 jurisdictions that we named: Toronto, Peel, and Hamilton. These exist under some form or another throughout the country within emergency management or health protection and promotion legislation. The health units that you deal with day to day, they have substantial discretion to come in, assess what you're doing, COVID-19 workplace health and safety plan, and basically check in and say, you know, what is going on? Where are we going here? What are you doing to contain this? And they have the authority to either partially or fully close you. These authorities existed before the most recent sort of rounds of class orders. One thing that we get asked all the time, and that I was asked earlier last week, how do we appeal this? You know, what do we do to get back up and running online? Well, at least in our jurisdiction, the appeal timeframes are set up so that they are actually longer than the 10-day closure period. And so in some ways, there's a hard stop limit to when the appeal hearing would even start to manage the closure and ensure that you know, we can even have a discussion about reopening before the end of that period of time. And so what are we talking about here? Key takeaway: you need to be proactive. You need to get on top of the regulations, the guidance, and ensuring that it is adhered to by any parties at the workplace. And there needs to be a proactive approach to this, as opposed to a reactive, blow the plume of dust off your safety plan approach, saying, hey, here's my positive plan. I'm sorry, it's dusty. and it says, you know, March of 2020.
Yeah. So one thing I wanted, before people get too scared, is public health officers are not in the business of closing you down. They don't want to do it. So if you can come to them with I'm concerned about the spread in the workplace, and here's how I want to deal with it, you may be able to negotiate a partial closure or a limited impact, which is far better than having your entire crew off limit. And so if you can work out a solution that addresses the joint concern that you and the public health office have about the spread of COVID-19, you're much more likely to get a good result. Because as Tushar just said, you know, doing the appeal is not going to actually get you the result you want, because it's going to take too long. And by that time, the period has already expired. So showing yourself to be professional and proactive and genuinely concerned about health and safety really makes a difference when you're negotiating with public health officers. Next slide, please. So yeah, well, these are the key takeaways. Risk management, you've heard it in the insurance and CCDC2 context. You're now hearing it in the COVID-19 context. We really believe in rapid antigen screening. It's really been something that we have seen great results with surprisingly small numbers of positive results. So people are using it as a tool. Physical distancing, enhanced sanitation, engineering, administrative controls. And what I mean by administrative controls is reminding your people. We all get sloppy after a time. And I have a crew out there that's actually building me an extension. They were really good at the beginning, and now they've got to be nudged to remember to do certain things, because we all get a little careful, sort of comfortable with the risk in a way that we shouldn't over time. Next slide. So recommended. One of the things I'm going to suggest, I'm a real believer in good masks. In the beginning of the pandemic, you could not find PPE, even in the healthcare system, there was a huge shortage. Now you can get excellent medical grade, certified, made in Canada masks. And I think you should be giving your workers medical grade masks, obviously rapid antigen testing. And we encourage you to think of a vaccine incentive encouragement policy. I know some of you who are listening, they already have this 3-hour paid, like in Saskatchewan and Manitoba and some other jurisdictions. But even if you don't have it, I encourage you to institute it. And also, if you're big enough and you think it's appropriate, have somebody local, a local doctor or officer, come in and talk to your population about why vaccines are safe for that particular population. That's what I call the encouragement policy. Final slide, I think, or last slide. Oh, yes. Okay, Tushar and I, we are both extroverts, if you can't tell. And we love talking case law. And Tushar, do you want to tell about what I call the Nelmar drywall nightmare?
Absolutely, happy to. And in case you thought we forgot, no, we didn't. We're always looking. So the employees at a particular project, in this particular case, employees of a subcontractor, a drywall subcontractor by the name of Nelmar, they hired an exotic dancer during the province-wide stay-at-home order, just in the last couple of weeks or so. And there were some images, videos, and clips that popped up both with respect to traditional media as well as social media of these individuals having a booze-fueled party. That's the only way that I can describe it. One thing that was readily apparent for the purposes of our focus on COVID-19 in 2021 is that there was no regard for the stay-at-home order. Nobody was wearing masks. There was no physical distancing, as you can imagine, and the video and the photographic evidence quite clearly demonstrated that it was conclusive, let's say. Another concern from the standpoint of the employer was the fact that the individuals that were filmed engaging and courting as such, they were wearing Nelmar Drywall t-shirts, and the logo of the company, as well as other key features, were quite readily apparent in the videos and photographs that popped up online. Nina, the employer came back with a zero tolerance approach. Maybe we can talk about that.
Well, zero tolerance is funny because I don't think our province enforces that, but I would query to what extent the values of not harassment, let's not have booze-filled parties, let's obey COVID-19, let's stay within the social distancing areas, if that was really enforced. Because when you see such a terrible breakdown of all sorts of policies, I cannot imagine a single one of our audience members has a policy saying it's okay to have exotic dancers at a construction site. And I can tell you that the exotic dancer was not wearing hard hat or boots. So she wasn't wearing the construction PPE, let alone the COVID-19 PPE. So the number of ways, it's almost like an exam question, Tushar. How many ways was the law violated at this point? But tongue in cheek, I mean, there is a reputational damage to when people do this. I'm sure this is only one crew. I'm hopeful that this was an aberration. And yet I know about this small contractor in Ontario, and I never did before. And this is not a good reputation to have. So I think one of the takeaways is, while we want to abide by COVID-19 requirements because it's the right thing to do and it's the legally required thing to do, we also have to be aware of the reputational damage if people aren't compliant. And social media is a swift judge, and it's far less interested in evidence and nuance than the judges of the Superior Court.
That is an absolutely fantastic way to frame it, Nina. I think that brings us to the end of our slides, and maybe we can pass it back. We will be, I believe, heading over soon to, oh, sorry, my mistake. We will distribute this afterwards for those that aren't able to jot down the web addresses as quickly as we can type. Nina is blisteringly fast. I've never seen someone type that quickly. But we have a very helpful COVID-19 Insights section on our website, as well as we will make sure to distribute an article that we prepared in Q4 of 2020 when the first couple of vaccines were first announced, and we really focus on a couple of key cases in the vaccinate or mask series, let's call it, from the unionized sector over the past decades. Those cases dealt primarily with influenza and policies that required an employee to either vaccinate or mask. We talk about how that might carry over to COVID-19. So we'll make sure that you have that and you're able to read it, offline and on your own time. And yeah, the insights section, I mean, that is where Sahil mentioned it earlier. We prepared an article on the recent Sudbury decision, the Court of Appeal decision. You can find a lot of building briefs and other helpful employment, labor and equalities resources there first.
Thank you, Tushar.
Great, thank you, Tushar and Nina. That was fantastic. I learned a lot myself. It's a never-ending battle trying to keep up. And as Tushar mentioned, we've got a great COVID website landing page for collecting current information, laws, rules, articles, other resources. We're tracking this all over the place. Our employment law and labor and equalities group deserve about a year's worth of holidays after the last year and a half of work. They've really been amazing. I work with them closely all the time. The different members, they've led up our essential workplaces task force, Craig Stair in Ottawa and Tina Aswad in Montreal and across the country, because it's been, as everybody can attest, to say it's been a challenging year, is an understatement, but it's been a challenge just to keep up with the changing of the laws. And especially knowing, at the last minute, that there's been a change in the shutdown orders in Ontario, for example, and needing to know immediately whether you have to send a notice out to employees not to show up to work the next day or not. We're tracking all of that. We've got a big team, both in our employment and labor and equalities group, as well as the construction team, putting out articles as fast as we can to keep track of the changing pace of laws and regulations and what's allowed and what's not. So thank you both for that. We are now going to move into something new that we're introducing this year, because we have moved national with our construction law forum and we are online. So we thought we'd take advantage of the ability to create breakout rooms, which will give everybody a chance, we're hoping, to raise questions that are, maybe you didn't have a chance to get an answer in the chat. Maybe you just want to talk through some of the issues that we talked about today. Maybe there's some specific provincial laws or regulations you want to talk about that are not even related to COVID, but also that might be related to COVID. It's a chance for everybody to get into a smaller group and ask a couple of closer questions and meet some of our amazing big team across the country. We've got in each of the breakout rooms, we're breaking the rooms up by province. You're welcome to join any room. I think they may have been assigned, but we're going to have some of our team members from each of the different provinces across the country ready to answer questions. We've got a big team. We've got one of the biggest construction groups in the country, frankly, in the world, because we are one of the largest law firms in the country. And so we're there to help you with any of your questions and also just to meet you. Normally we would be doing these in person. We'd have some coffee, we'd chat. Maybe there's a question that's been bugging you and you just want to ask somebody, or you just want to make a connection with one of us. This is your chance to do it, at least digitally. So we're looking forward to starting that. Before we head into the breakout rooms, just want to take a moment to thank everybody for taking an hour and a half out of their busy days. It's a delight to at least know that many have joined up, if not actually to see you and meet with you in person. I wanted to thank Sahil and Cindy for putting together a really great program. I think they picked some very topical subject matters, and I think we've all learned a lot. And in particular, Sahil, who's been writing furiously, going to court, doing his work, writing furiously on all these cases, as well as having a baby in the middle of all this. So, we're all very busy, and we're very, very grateful for Cindy and Sahil, but also for Margaret Williams and Shannon Wadsworth, who helped put the program together, did all the back, behind the scenes technology and emails and invitations that make all this work and make our jobs a lot easier. So thank you to everyone. After the webinar is done, we will be sending out a survey. We do strongly encourage you and ask you to fill that out. We're all trying to make the best program, give you the best content, subject matter in the most interesting format that we can. It's a new world. Obviously, we're trying these breakout rooms for the first time in this format across the country. Give us your feedback. Let us know what worked well, and we'll keep doing more of that. Let us know what didn't really work so well, and we'll try to do less of that or improve on that. Your feedback is really valuable, and we want to hear from you. So please complete that when you see that. And as I said earlier, the program today has been recorded. It will be on our website in a couple of days. The slides as well are available, and I believe they have contact information for all of the presenters today. But if you ever needed to reach out, feel free to go to our website. In the construction and infrastructure section of the website, you'll see my name, and I can connect you with whoever you need to speak to. So with that, we will move over and into our breakout rooms. Thank you, everybody. See you in the fall.